Good afternoon, ma'am. Could you please state your name and provide your date of birth?
Yes, Kylie Blair.
Thank you, Ms. Blair. And counsel for Ms. Blair, if you could please announce.
Good evening, Your Honor. Chris Doran on behalf of Kylie Blair.
Thank you, Mr. Doran. And appearance on behalf of the state?
Barbara Perez-Condola for the state.
All right, thank you, Ms. Perez-Condola. All right, Ms. Blair, you are here on a Superior Court new case. I find probable cause for the allegations of one count of aggravated assault, a Class 4 felony, one count of criminal damage, a Class 1 misdemeanor, one count of disorderly conduct, fighting, a Class 1 misdemeanor. Mr. Duran, it's my understanding you did attempt to send us some video, and I just wish to let you know that initial appearance court is not, we don't hold evidentiary hearings. The question before me is simply whether there's probable cause based off of the Form 4 that was filed by the police. Do you wish to be heard regarding that?
If I could briefly, I understand and respect the court's decision, Your Honor. I believe under 4.2A4, when the court's making that probable cause determination, it may be unusual for the court to have anything more than what's stated in the Form 4. However, in this circumstance, I was asking the court to consider, and I am asking the court to consider a 2-minute video that captures the incident, because I believe on that video that I have sent to the state as well, it would show that Ms. Blair didn't, in fact, kick a police officer. And so that's the only reason that I was asking the court to view it. If the court's going to make a determination about probable cause, there is video evidence that I think would get the court to a different determination.
Right. So let me explain again that, again, I'm only allowed to consider what the police have filed in the Form 4. I'll also explain to you, as well as to Ms. Gibbons, that me finding probable cause based on what's in the police report, that's not a finding of guilt. It's not anything close to that. It's just based on that, would there be enough information for there to be probable cause for those charges? The prosecutor's office still has to decide whether they wish to file those charges or not. Mr. Duran, I'd also point out, if you look at Rule 5 of the Arizona Rules of Criminal Procedure, that specifically has sections regarding evidence and witness testimony, all of which are absent from Rule 4. So is it still your position that I'm supposed to consider evidence today, despite the fact that that's lacking from Rule 4?
Your Honor, my position is I think that this is a unique circumstance for me as well. However, I don't believe that there is anything in the rules or in the case law that says that a court cannot consider anything other than the Form 4. If there is, I'm unfamiliar with it, and I would defer to the court. But I don't think there's anything that prevents the court from considering something, especially a video of this incident that the court's determining probable cause on. I think 4.2A4 just says that the court must make a probable cause determination, and it doesn't say based only on the Form 4. So I respect the court's decision, whatever that is, but I at least wanted to make a record of that and bring it to the court's attention that that video does exist.
Okay. No, your position is noted, Mr. Duran. If you believe that I'm acting improperly or against the rules, you are certainly welcome to file an appeal. Ms. Perez-Condola, briefly, does the state wish to be heard on this subject?
Your Honor, I do agree that the rules don't allow for it as far as the taking of evidence. I will say I did receive it. I saw it. If you were to allow him to make his arguments about probable cause, I'm ready to address those based on what I saw, but that's getting into another sticky wicket because it obviously isn't an evidence and you haven't had the chance to see the video, which I think is proper. But I don't think I think he can make his arguments in a certain fashion and then I can make mine without that. It cannot be marked and admitted. That is correct. This is not the place to mark, admit, and admit evidence, such as the Ring doorbell camera footage.
Thank you, Ms. Perez-Condola. Yeah, so I'll state again, we do not take evidence for initial appearance hearings. We don't have a way to take evidence for initial appearance hearings. I can't mark it as an exhibit I can't issue a minute entry regarding that. We don't have that ability here at Initial Appearance Court. The only thing we're able to produce is release orders and warrants. So again, Rule 4, which is what applies to initial appearance, does not state anything regarding evidence or witnesses. Rule 5, which is about preliminary hearings, does in fact include that information. So my reading of the law is that it would be improper for me to consider any evidence. The only thing I am considering is the Form 4. Mr. Duran, if you wish to be heard regarding probable cause based off of the Form 4, I will consider that, but I will not consider any video or reference to any video.
Understood, Your Honor. Like I said, I respect the court's decision. I'll just put the state on notice that if they seek alternative means other than a preliminary hearing, I'd ask them to play the video that way. But to the court's point about probable cause based on the Form 4, Your Honor, strictly based on the Form 4, I guess that I'll note by its confines, it doesn't reference anything that the alleged victim in this case, that her peace and quiet was ever disturbed. So I think if we're only looking at the Form 4, then at least the misdemeanor for disorderly conduct, there is not probable cause for the misdemeanor. I can't make that same argument for the felony, like the video that I wanted to present, because I believe there is probable cause if you just base it solely on the Form 4. But for the misdemeanor of disorderly conduct, there hasn't been any allegation or anything presented in there that there was a peace and quiet that was disturbed. In fact, I think it says the opposite, that there was a state of an argument and a family fight, so there wasn't a state of peace and quiet. So I don't think the court can find probable cause for that misdemeanor.
Thank you, Mr. Duran. Ms. Perez-Condola, does the state wish to be heard regarding probable cause?
Your Honor, with the Form 4, I believe it does lay out that the victim was in a position where she felt her personal space was being encroached on. And I think if you read the Form 4 in its totality, that her personal space, she has to make room, then her shirt gets ripped, the father has to intervene. I don't think there's anything saying that specific words that her peace are disturbed, but you can read the totality, and with that charge of finding can be made at this stage of the low standard of probable cause that the disorderly has enough PC.
Thank you, Ms. Perez-Condola. All right. So I do find that there's probable cause for all of the allegations. In particular, the court's not aware of any way that someone could not have their shirt ripped off and that would not disturb their peace. So I do find, and also it's disorderly conduct fighting, I do find that there is probable cause for that, for criminal damage, as well as for the aggravated assault of the officer. Again, I'll state, Ms. Gibbons, that does not mean you are guilty of any of these things. I'm only getting one bit of information here, and so there's many ways that this case still can go, and you will have an opportunity to be heard in court if the prosecutor's office decides to bring these charges. Mr. Duran, let me ask you regarding, are you going to be the attorney of record going forward, or is this just for today's hearing?
I'm going to be the attorney of record going forward, Your Honor.
Okay, just one moment then. Let me... Okay. All right. Then regarding release conditions, let me hear first from the state, and then I'll hear from Mr. Duran.
Yes, Your Honor. And if you wouldn't mind, I just want to address one thing, mainly just so that we get it at a point where I can say something just about the video and the charging. I just want to, and I'm sorry, I should know your name. I would want defense counsel to know that I am not following this case. I don't follow anything from IA. There will be a person assigned who will review for charging, and I don't know who that is yet. And so I don't mean to be difficult, but as far as that video, and I know you want our office to consider it, I would ask if you could call our main line, and they will be able to, on Monday, be able to tell you who is assigned, and if you can get that to the person. I'm off next week, and again, this is so rare. I just want you to know that I'm not trying to not get it in the right hands. but I just need to kind of volley that back to you that that would be the way to make sure that if you want that reviewed in the right hands. My recommendation for bond is, well, not a bond. My recommendation is for pretrial services supervision, to have release terms to not possess a firearm, don't return to the incident location, electronic monitoring because this is a DV situation, no direct or indirect contact with the victim, do not consume any alcohol or ingest in illegal substances, and also to have alcohol and drug testing and monitoring. I do note the lack of, I don't see criminal history. I note in the Form 4C what's said about how the suspect has possibly been living with a history of substance abuse and possibly mental health issues. So I take that into account. I just need to, I do emphasize, though, that this is a volatile situation, and emotions are flaring, and obviously, I always have to be concerned about public community safety, victim safety, community safety, and I just hope that those things for the release conditions and having supervision will be enough to ensure that in this DV situation. Thank you, Your Honor.
Thank you, Ms. Paris-Lindois. All right, Mr. Duran, regarding release conditions.
Your Honor, we're asking for OR release. Ms. Blair has no criminal history of any kind. The probable cause statement, I know there's a box that's checked in terms of alcohol may be a problem or mental health, but there is no allegations in the Form 4. There's nothing from police with all of their interactions indicating that Ms. Blair was under the influence of anything. So I think that OR release would be appropriate. I want the court to know that she has 5 children that are under the age of 7 years old. 7 is the highest, and she has as young as a 10-month-old that she cares for primarily. Her husband works full-time. She is their sole provider. She has a job at Mountainside Fitness that she works for, and she takes her kids to the daycare there while she's working to kind of do both at the same time. She lives in a house with her mother, the alleged victim in this case. I'd ask the court to put in the release conditions that she's not to initiate contact with the victim, and there should be no uninvited contact. But I can't imagine that her mother is not going to want her to come home and be able to be there for her 5 children that live there too and care. I think if the court puts not to initiate contact and no uninvited contact, that will give Miss Blair the ability to go home and to care for her children. I don't think pretrial services is necessary. She's a lifetime resident of Mesa, Arizona. She works in Mesa, Arizona. She's not a flight risk, and because of the lack of criminal history, I don't think that level of supervision is important or is needed at this time.
Okay. Thank you, Mr. Duran. All right. Well, let me explain then, to start off with, that anytime there's a domestic violence incident, and it can be as simple as someone taking a cell phone from someone else and throwing it, people get heated in an argument or something like that, that there are standard conditions and restrictions of release that we put in about no contact. And so I have done that here. I've heard what you said, Mr. Duran. I appreciate it. I heard what you've said, Ms. Paris-Lindois, on behalf of the state. I appreciate what both counsel have had to say in this case and have considered it. Ms. Gibbons, your hearing will be at the downtown Phoenix Superior Courthouse. Your first hearing is called a status conference. It will be July 22nd, 8:31 a.m. You have a preliminary hearing July 24th, 8:31 a.m. I am going to release you on supervised release, Ms. Gibbons, but without an ankle monitor. So that means you will be released in approximately 6 hours from now, and you will be provided information and must comply with supervision.
Okay.
Because you're being released, you're promising to go to court on all of your court dates. All of that information will be in your paperwork. You also must comply with the standard conditions and restrictions of release. These are subject to change. Another judge can modify these. So these are in place at this time. So you're not to return to the scene of the alleged crime. You're not to initiate contact with any alleged victims, complainants, or witnesses, or have any physical contact with any alleged victims. You're not to possess any weapons. You must find an alternative residence and provide proof of the same to the court. You must obey the terms of any order of protection or injunction against harassment that has been issued or which may be issued. You may have no contact with any victims for any reason, even if they contact you first. You may not reside at the same location as an alleged victim, even if you are an owner or renter of the residence. You're entitled to one civil standby. That's where you contact local law enforcement, schedule a time to meet an officer who will escort you to the residence so that you can obtain your essential belongings. And please be aware, violation of a no victim contact order in a criminal case may constitute aggravated harassment, which is a Class 6 felony. If your husband's also residing there, he can probably get your things for you, and that saves, having to involve law enforcement, but again, you have that option if you wish. All right. Mr. Duran, do you have anything further for the court?
No, Your Honor. I think that you clarified. I think at first you said don't initiate contact with the victim, but later on you said no contact at all, so it sounds like there's no contact.
That's correct. There's no contact. All right. And Ms. Perez-Gondola, does they have anything further?
No, Your Honor.
All right. Thank you, Ms. Perez-Gondola. Thank you, Mr. Duran. Thank you, Ms. Blair.
Thank you.
Thank you, Your Honor.
Thank you.
Kylie, I'll talk to you soon.